Imagine, you do a really simple favor for a friend.
Right.
Like they run a small online business and they ask you to drop a seemingly harmless, sealed package off at the shipping center. And, you agree.
Yeah, you wouldn't even think twice about it.
Exactly. But then, a month later, you are suddenly served with this devastating lawsuit. It turns out that package contains something, well, highly illegal. Or maybe it was stolen intellectual property. And because your name is on that shipping ledger, you are caught right in the legal crosshairs.
Oh, wow. That is a nightmare scenario.
It really is. You are suddenly facing ruinous legal fees, potential damages, everything. So the question is, who pays for that? Do you just have to absorb the total destruction of your finances for doing a favor? Or does the law actually force your friend to cover, every single penny of your losses, even if you two never signed any sort of formal contract?
That is the big question, isn't it?
Yeah. Welcome to the invisible architecture of risk.
I love that phrasing, because it really is an architecture that governs almost every interaction we have, whether it's personal or commercial. What we are examining today are the fundamental ways the law allows us to, transfer, manage, and basically survive financial and legal jeopardy.
Right.
Specifically, we are going to look at the statutory frameworks found in Paper 1, Law of Contract 2, Unit 1. We are decoding two massive pillars of contract law today: the contract of indemnity and the contract of guarantee.
And look, if you are sitting there listening to this and thinking, well, this is strictly the domain of corporate lawyers and investment bankers, let me reframe this for you.
Please do.
If you have ever co-signed a car loan for a family member, right? Or if you have ever purchased an insurance policy for your home, or even if you have just asked someone to stick their neck out for you in a seemingly informal setting, you have stepped directly into this arena.
You absolutely have. You are an active participant in risk transfer.
Yeah. So our mission for this session is to dismantle the exact mechanics of how you are legally protected, and conversely, how you are completely exposed when things inevitably go wrong.
And the distinction between being protected and exposed often comes down to the precise phrasing of these legal instruments. I mean, it's all in the details.
It always is.
So to navigate this, we will first isolate the contract of indemnity, which functions as a direct two-party protective shield. Once we understand its boundaries, we will examine the contract of guarantee, which is, well, it's an entirely different beast.
A whole different animal.
Yeah, it's a tripartite safety net designed to engineer trust where none naturally exists. And finally, we will place them side by side to expose their structural differences, which will give you the tools to identify exactly what kind of legal gravity you are dealing with in any contract you encounter.
I'm excited. Let's pull apart this first mechanism, the contract of indemnity. I conceptualize this as like a financial firewall.
Okay, I like that.
If I am operating a business or simply navigating life and I spark a liability, this contract is designed to contain the blaze, right? And absorb the financial shock.
That is a highly functional way to visualize it. But to understand exactly how thick that firewall is, we must anchor ourselves to the actual statutory definition.
Right, let's get into the text.
So, under Section 124 of the Indian Contract Act of 1872, a contract of indemnity is defined very explicitly. It is a contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person.
Wait, I need to pause you right there.
Sure.
Because the phrasing of that statute feels incredibly specific and maybe a little narrow. It says, caused by the conduct of the promisor or any other person. It's entirely focused on human behavior.
You caught that.
Yeah. So let's test the limits of this firewall. Say I own a warehouse and I sign what I think is a really broad indemnity agreement to protect my business from loss. A week later, a catastrophic lightning strike burns the warehouse completely to the foundation. Based strictly on Section 124, am I actually protected?
Under the rigid statutory interpretation of Section 124 of the Indian Contract Act, you are not protected.
That is terrifying. A total loss, and the firewall just fails because of the source of the fire.
Precisely, because Section 124 mandates human agency. The text requires the loss to be generated by the conduct of a person.
Wow.
A lightning strike, a sudden flood, an earthquake, these are acts of nature. They lack a human perpetrator. Therefore, a contract strictly adhering to Section 124 would not cover that devastation.
That feels like a massive loophole.
It is a significant limitation. However, the source material draws a vital, really fascinating contrast here with English law. The English legal system approaches this with a vastly wider lens.
Okay, how so?
Under English common law, a contract of indemnity is simply a promise to save another harmless from loss caused as a result of a transaction entered into at the instance of the promisor. It doesn't obsess over human conduct.
So the English system essentially says, a loss is a loss, regardless of whether a human or a hurricane caused it. The umbrella is just structurally larger.
It is entirely comprehensive. In fact, under English law, every single contract of insurance, with one singular exception, which is life insurance, is legally classified as a contract of indemnity.
Wait, really? Every insurance contract?
Every single one. Property insurance, fire insurance, marine insurance, they all fall under this umbrella because they are promises to make good a specific financial loss, regardless of the inciting incident.
Okay, so why is life insurance the exception?
Because human life cannot be assigned a strictly compensatory financial metric, right? It's a contingent contract to pay a fixed sum upon death, not to merely reimburse a measured exact financial loss. You can't say a person is worth exactly $50,000 in the same way you can value a burned-down warehouse.
That makes total sense. And that distinction between the Indian requirement for human agency and the English allowance for natural accidents, that's something you absolutely must keep in mind if you are drafting or signing agreements across different jurisdictions.
Exactly. Although, practically speaking, modern Indian courts often view commercial indemnity clauses with a more pragmatic, broader perspective to facilitate business. But the strict statutory baseline of Section 124 remains completely tethered to human conduct.
Right. Okay. Let's populate this legal structure. For this firewall to exist, who actually has to be at the table? It sounds like a pretty closed ecosystem.
It is strictly a two-party ecosystem.
Okay.
The first party is the indemnifier. This is the entity or individual making the solemn promise to absorb the loss. They provide the financial backing.
So they are the ones writing the check when things go south.
Exactly. And the second party is the indemnified, which is also known in legal parlance as the indemnity holder.
Yeah.
This is the individual holding the shield, the one whose potential losses are going to be made whole.
And beyond simply having those two people in a room, what transforms their conversation into an enforceable legal instrument?
It requires the foundational elements of any valid contract. There must be an offer and acceptance, free consent without coercion or fraud, and both parties must have the legal competency to contract, meaning they are of sound mind and the age of majority.
Right, the basics.
Yeah. But most crucially, the singular purpose of this specific agreement must be protection against a specified loss.
The sources offer a rather elegant, stripped-down hypothetical that crystallizes this. Imagine person A approaches person B.
Okay.
Person A says, look, I want you to engage in a transaction with person C involving 200 rupees. If person C turns around and sues you over this, I promise to indemnify you against the consequences of those legal proceedings.
That scenario is the quintessential express contract of indemnity. Person A has proactively erected a legal and financial barrier around person B. Person A, the indemnifier, is legally bound to step in if, and only if, person C initiates the action that causes the defined financial harm to person B, the indemnity holder.
The clarity of that is really satisfying, but my mind immediately hunts for the exploits in the system.
As it should.
The law protects legitimate commerce, sure. But what happens when the underlying action isn't a simple 200 rupee trade? What if the action is inherently malicious?
I see where you're going.
Let's push this into uncomfortable territory. Say I am running a highly aggressive corporate takeover. I hire a security consultant and I explicitly instruct him, go to our rival's headquarters and physically dismantle their server room. Just smash it. And if you are sued for trespassing and property damage, I will sign an ironclad indemnity contract right now to cover every cent of your legal fees and any damages assessed against you. Does the law recognize that firewall?
The law absolutely obliterates that firewall. Completely. This brings us to the illegal act exception, which serves as a profound structural limitation on the power of indemnity. The legal system exists to maintain public order and enforce rights, right?
Right.
It will violently reject any attempt to use its own mechanisms like contract law to facilitate, fund, or insulate criminal behavior or civil wrongs. The source material actually provides two very vivid historical illustrations to cement this doctrine.
Let's hear them. Walk us through the first illustration. Let's see how the courts handled deliberate malice.
The first illustration directly mirrors your corporate espionage hypothetical, but with raw physical violence.
Okay, darker.
Yeah. Person A employs person B to physically beat person C.
Wow, okay.
To convince B to commit the assault, A formally agrees to indemnify B against all consequences of the act. So B, trusting this financial shield, proceeds to beat C. Inevitably, C files a lawsuit against B for battery, and the court orders B to pay substantial damages to C.
Right, so B has suffered the exact financial loss that A promised to cover. B takes the court judgment, slides it across the desk to A, and demands the money.
And A can legally refuse to pay a single rupee.
Wow, even though there was a contract?
Even though there was an explicit agreement. If B attempts to sue A to enforce the indemnity contract, the court will dismiss B's claim entirely. The ruling principle is absolute. A is not liable to indemnify B.
Because the act was illegal?
Exactly. The underlying act assaulting C is a manifest tort and a criminal offense. The court will not legitimize a contract that essentially acts as a funding mechanism for a hitman.
The logic is undeniable. I mean, you cannot weaponize contract law against the broader justice system.
Precisely. And the second illustration shifts the focus from physical harm to reputational destruction, demonstrating that this principle applies to all intentional torts.
Okay, what's the scenario?
Imagine B is the proprietor of a widely circulated newspaper. A approaches B with a malicious objective. A requests that B publish a highly defamatory, false statement, a libel against C in the newspaper. Now, B is hesitant, fearing a lawsuit. So A promises, if you print this libel, I agree to completely indemnify you against all consequences of the publication, including any costs and damages from any legal action C might take.
So A is essentially renting B's printing press to destroy C's reputation, using the indemnity promise to neutralize B's risk assessment.
That's exactly what's happening.
Yeah.
B publishes the libel, C's reputation is damaged, C sues B for defamation, and C wins a massive judgment. B incurs heavy damages and attorney fees.
And B goes to A for the money.
Right. But when B attempts to enforce the indemnity agreement against A, the result is identical to the assault case. A is completely shielded from liability to B.
Because it's a tort.
Because publishing a known libel is a tortious act. The agreement to indemnify the publisher is void against public policy. The state will not act as an underwriter for intentional defamation.
That is a critical boundary for you to understand as a listener. The moment an indemnity contract is used to insulate deliberate wrongdoing or illegal acts, it ceases to exist in the eyes of the law.
It just evaporates.
So we have established the parameters of the shield and its limitations. Now, let's explore the aftermath of a legitimate disaster.
Okay.
The catastrophic event has occurred, the lawsuit has been filed, I am the indemnity holder, and my actions were entirely lawful. What specifically can I extract from my indemnifier? Because this isn't just about handing over a receipt, right? This is a complex extraction of rights.
It is a very specific extraction, detailed under Section 125 of the Indian Contract Act. Section 125 delineates the precise rights of the indemnity holder when they are sued. But the absolute non-negotiable prerequisite to invoking any of these rights is that you, the indemnity holder, must have been acting within the scope of your granted authority.
Right. You can't go rogue.
Exactly. Assuming you haven't gone rogue, you possess 3 distinct, powerful rights to ensure you are made completely whole.
Let's analyze the anatomy of that recovery. What is the first pillar of Section 125?
The first pillar is the right to recover damages. You are legally entitled to recover all damages which you may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies.
Okay.
This is the most direct application of the contract. If a judge pounds the gavel and orders you to pay 50,000 rupees to a third party for an incident covered under our agreement, I, as your indemnifier, am obligated to provide that exact 50,000 rupees. It is a one-to-one reimbursement of the judicial penalty.
That seems straightforward enough, but anyone who has ever brushed against the legal system knows the actual judgment is often just a fraction of the total economic destruction.
Oh, absolutely.
The process is the punishment. You have retainer fees, exorbitant hourly rates for attorneys, filing costs, discovery expenses. Does the indemnifier have to absorb the collateral damage of simply defending myself?
They do, and this forms the second pillar, the right to recover costs. You are entitled to compel the indemnifier to cover all costs incidental to the institution and defending of the suit.
That's a huge relief.
It is, however, this is where the law introduces a profound behavioral constraint. You can recover these costs, but only under highly specific conditions.
Ah. I suspected there was a catch. I can't just retain the most luxurious, predatory law firm on the continent, demand private jets for my legal team, and forward the invoice to the indemnifier. There has to be a mechanism to prevent moral hazard.
The law prevents that moral hazard through the standard of prudence. Section 125 dictates that you can only recover those costs if, in bringing or defending the suit, you did not contravene the orders of the promisor, the indemnifier. Furthermore, you must have acted as it would have been prudent for you to act in the absence of any contract of indemnity.
Wow, that phrase, prudent in the absence of any contract of indemnity, is a masterpiece of legal engineering.
It really is.
It completely changes the psychological dynamic. It forces the indemnity holder to pretend the shield doesn't exist when making strategic decisions. You have to litigate as if every single rupee is draining out of your own personal savings account.
It enforces absolute good faith. If your indemnifier analyzes the lawsuit, realizes it's a losing battle, and explicitly orders you to minimize losses and settle, but you decide to fight a scorched earth legal campaign purely out of ego, you have contravened their orders.
And you eat those costs.
You cannot recover those inflated litigation costs. Conversely, if the indemnifier explicitly authorizes you to aggressively defend the suit, then your costs are entirely covered, regardless of the final bill, because you were acting under their direct instruction.
Makes sense.
The alternative is that you lack instruction, in which case the court will scrutinize your legal strategy and ask, would a rational person spending their own money have filed these expensive motions? If the answer is no, the indemnifier doesn't pay for them.
It is a brilliant systemic check against reckless litigation. Now, what happens if the lawsuit never reaches a final verdict? Litigation is a war of attrition, and often the most rational move is to stop the bleeding and settle out of court. Does Section 125 accommodate compromises?
It does, through the third pillar, the right to recover sums paid under compromise. If you settle the lawsuit, you are entitled to recover all amounts which you have paid under the terms of that compromise.
Okay.
But, exactly as we saw with litigation costs, this right is governed by the same strict behavioral constraints.
So the prudence standard applies here too. I can't just grow tired of the stress, offer the plaintiff a massive, unjustified settlement simply to make them go away, and expect my indemnifier to cheerfully fund my impatience.
Precisely. The statute insists that the compromise must not be contrary to the orders of the promisor, and crucially, it must be a settlement which it would have been prudent for the promisee to make if there were no indemnity contract.
The same exact test.
Right. If a reasonable person facing that legal exposure without an indemnity net would have settled for that amount, the indemnifier must pay it. Additionally, if the indemnifier explicitly reviewed the settlement terms and authorized you to compromise the suit, you are fully within your rights to recover that exact sum. Authority and prudence are the gatekeepers to your recovery.
We have thoroughly mapped the what damages, costs, and compromise sums, but now we arrive at a conceptual juncture that I find utterly fascinating because it deals with the timeline of financial ruin.
Okay, let's get into it.
Let's talk about the when. The commencement of liability. I am the indemnity holder. The court has just ordered me to pay a massive settlement. My question is, do I have to actually liquidate my assets, empty my bank accounts, and physically hand the cash to the plaintiff before I can turn to my indemnifier for reimbursement? Must I be financially broken first?
Your question touches upon one of the most significant, hard-fought evolutions in the history of commercial law. It represents a monumental shift from rigid algorithmic common law to the more nuanced, fairness-driven principles of equity courts.
How bad was it originally?
Historically, under the strict Old English common law, your worst fears were the reality. The answer was yes. The prevailing legal maxim was brutal in its simplicity. It was, you must be damnified before you can claim to be indemnified.
Damnified, meaning you had to actually suffer the damnation of the out-of-pocket loss. You had to bleed your own cash before the shield would activate.
Exactly. The orthodox view was that an indemnity contract was strictly a contract of reimbursement. Therefore, liability only arose after the indemnity holder had suffered actual tangible loss by paying off the claim. If a judgment was entered against you for 1,000,000 rupees, but you hadn't written the check yet, you had suffered a legal liability, but not an out-of-pocket loss.
Which means no protection yet.
Right. You had no right to demand the 1,000,000 rupees from your indemnifier.
But that completely subverts the utility of the contract. I mean, the entire reason someone seeks an indemnity agreement is often because they lack the capital to absorb the risk in the first place.
Exactly.
If I am hit with a judgment that exceeds my net worth, I physically cannot pay it. And if I cannot pay it, the old common law says I cannot be indemnified. The protection evaporates precisely at the moment of maximum peril. It is a paradox that leads to ruin.
It was a devastating paradox, and the courts of equity eventually recognized the absurdity of it. Forcing a party into insolvency before activating their contractual protection defeated the entire commercial purpose of risk transfer.
Absolutely.
This realization birthed the modern shift, which Indian courts have fully embraced. This new paradigm was eloquently articulated in landmark English equitable rulings like Richardson re ex parte, the governors of St. Thomas's Hospital, and it was firmly cemented in Indian jurisprudence in cases like Osman Jamal and Sons Ltd v. Gopal Purushottam.
So what was the philosophical breakthrough in Osman Jamal? How did they rewire the timeline?
The court in Osman Jamal observed a fundamental, equitable truth about the nature of protection. They declared, indemnity is not necessarily given by repayment after payment. Indemnity requires that the party to be indemnified shall never be called upon to pay.
I want you, the listener, to let that phrase sink in because it is a total inversion of the old rule. The party to be indemnified shall never be called upon to pay.
It's powerful.
The shield is no longer a sponge meant to mop up the blood after you've been wounded. It is a physical barrier that must intercept the blow before it ever touches your skin.
That is the perfect visualization of the modern rule. The law now dictates that the liability of the indemnifier commences as soon as the liability of the indemnity holder becomes absolute and certain.
So the moment the gavel drops.
The moment the judge signs the order against you, your legal liability is absolute. Even if your bank account is entirely untouched, you are legally entitled to immediately call upon the indemnifier. You can demand that they step forward, assume the burden, and pay the liability directly to the third party, or that they deposit the funds with you so you can satisfy the judgment.
The source material gives a clean example to illustrate this proactive protection. Person X promises to compensate Person Y for any financial loss resulting from Y filing a specific lawsuit against Person Z. The lawsuit happens, it goes poorly, and the court orders Y to pay Z 5,000 rupees in costs. Under the modern equitable rule, because the court order makes the loss absolute and certain, Y can immediately claim the 5,000 rupees from X to satisfy the court order. Y never has to drain their own operating capital.
It is a triumph of practical justice over rigid legal formalism. Now, we have spent considerable time examining express contracts written, deliberate promises of protection.
The ones you sign on paper.
Right. But to truly understand the depth of indemnity law, we must venture into the territory of implied indemnity. The law has the power to construct an invisible indemnity contract around you based entirely on your actions, even if you never signed a single document.
This concept completely shattered my understanding of contractual limits. Let's dissect the case of Dugdale v. Livering.
Oh, this is a great case.
The facts here read like a logistics nightmare that slowly morphs into a profound legal precedent. Set the scene for us.
The scenario in Dugdale v. Livering involves a high-stakes standoff over physical property. The plaintiff in this case was a business in physical possession of several railway trucks. However, the legal ownership of these trucks was intensely disputed. Two separate entities were claiming absolute ownership. The defendants, named Lovering, and another entirely separate company known as the KP Company.
The plaintiff is essentially trapped in the middle of a corporate tug-of-war. They have the assets, but handing them to the wrong party will trigger a massive lawsuit for conversion, which is the civil wrong of giving away someone else's property.
Precisely. And the defendants, Lovering, aggressively demanded that the plaintiff deliver the trucks directly to them. The plaintiff, recognizing the extreme legal peril, responded cautiously. They essentially told Lovering, look, we're willing to surrender these trucks to you, but given the competing claim by KP Company, we require an indemnity bond first.
Very smart.
If we give you the trucks and KP Company subsequently sues us for conversion, you must formally agree to cover our legal losses.
A highly prudent demand. So did Lovering agree to the terms and sign the bond?
This is where the legal friction occurs. Lovering received the explicit request for the indemnity bond, but they remained entirely silent.
They just ignored it.
They gave no reply, neither confirming nor denying the request. Yet, despite this silence, and likely due to massive commercial pressure, the plaintiff proceeded to deliver the railway trucks to Lovering anyway.
Oh no, the plaintiff blinked. And I can predict exactly what happens next. The KP Company, discovering their assets have been handed to a rival, unleashes their legal team on the plaintiff.
They did. KP Company sued the plaintiff for conversion and successfully proved their ownership. The plaintiff was held liable and was forced to pay substantial damages for improperly surrendering the trucks.
Ouch.
Having suffered this severe financial loss, the plaintiff pivoted and sued the defendants, Lovering demanding indemnity.
Lovering's defense strategy seems obvious here. They would argue, well, we never signed your bond. We explicitly ignored your demand for a contract. You cannot enforce a contract that we never accepted.
That's exactly what they argued.
How did the court dismantle that defense?
The court recognized that a rigid adherence to written contracts would result in a gross injustice here. They laid down a profound equitable principle regarding implied promises. The court ruled that because the plaintiff acted upon the direct request of the defendant, the demand to deliver the trucks, the plaintiff was entitled to assume that if their compliance turned out to be wrongful against a third party, they would be indemnified by the party who instigated the action.
Wow. The conduct itself forged the contract. By demanding the trucks, Lovering implicitly agreed to bear the risk of that demand.
Yes. The demand, coupled with the plaintiff's compliance, created an implied promise of indemnity. The silence regarding the bond did not negate the equitable obligation created by their request.
That is a stunning mechanism. But the sources provide another case that elevates this concept to an almost systemic level of importance. Secretary of State v. Bank of India.
Yes.
If Dugdale was a logistics nightmare, this is a financial thriller involving forged government debt. Unpack the mechanism of this fraud.
The stakes in this case are exceptionally high. It begins with a broker who is in physical possession of a government promissory note, a highly secure, negotiable instrument of state debt. However, the broker has committed a severe crime. He has forged the endorsement on the note, making it appear as though he is the legitimate holder.
The broker takes this toxic forged asset and introduces it into the banking system.
He does. He takes the forged note to the Bank of India. Now, it is crucial to note that the Bank of India acted in perfect good faith. The forgery was sophisticated enough that the bank, applying standard commercial scrutiny, failed to detect it. Believing they were handling a legitimate government security, they accepted the note from the broker.
So the bank is an entirely innocent actor here. They are merely processing what they believe is a standard transaction.
Exactly. The bank then takes the next logical commercial step. They present this forged note to the Public Debt Office, the government entity responsible for issuing these securities, and apply for the note to be renewed in the bank's name.
And the government.
The government office, also failing to detect the underlying forgery, processes the application, cancels the forged note, and issues a fresh, perfectly legitimate, renewed promissory note directly to the Bank of India.
This is wild. The forgery has now been laundered through the state apparatus itself. The fake note has been exchanged for a real one. When does the system realize it has been compromised?
Eventually, the true, original owner of the promissory note discovers the theft and the subsequent fraudulent transfer. The true owner files a massive lawsuit against the Secretary of State, the government, for conversion. The owner argues, you, the state, took my property, canceled it based on a forgery, and gave the value to a bank without my consent.
And the true owner is absolutely right.
They are. The true owner wins the lawsuit. The government is forced to pay heavy damages to compensate the true owner for the converted value of the note. Naturally, the government, having suffered a severe financial loss due to a fraudulent transaction, seeks to recover those funds. They turn their sights on the Bank of India and sue them for indemnity.
Let's analyze the bank's position. I mean, the bank must be outraged. They would argue, we are an innocent victim of the broker's fraud, too. We acted in absolute good faith. We didn't forge anything, and we certainly never signed a contract of indemnity with the government. We merely asked you to renew a note. On what grounds could the court possibly hold the innocent bank liable to protect the government?
The court resolved this by deploying the ultimate application of the implied indemnity rule. They held that it is a foundational general principle of law that when an act is done by one person at the request of another, in this scenario, the government renewing the note strictly at the bank's request, and that requested act is not in itself manifestly tortious or illegal to the knowledge of the person doing it, and yet such act ultimately turns out to be injurious to the rights of a third person, the person doing the act is legally entitled to an indemnity from the person who requested it.
I want to break down the gravity of that ruling for you, the listener, because it is breathtaking. The court acknowledges the bank's innocence, but the court essentially says innocence does not absolve you of the systemic risk you introduce.
Exactly.
By asking the government to process that transaction, the bank set the gears of the state machinery in motion. When those gears inadvertently ground up the rights of the true owner, the law dictates that the party who pushed the button must bear the ultimate financial responsibility.
Regardless of their intent.
Right. Even without a shred of paper between them, the bank's request implicitly created a binding obligation to shield the government from the fallout.
It is a profound demonstration that indemnity is not merely a defensive clause drafted by lawyers. It's an active, equitable force used by the judiciary to ensure that financial ruin lands on the party who instigates an action.
That concludes our exploration of the direct two-party shield of indemnity. We've charted its boundaries, its intolerance for malice, the robust rights it confers upon the holder, and the invisible implied variations that can arise from a simple request. But now we must undergo a significant paradigm shift.
Yes, moving on to the next structure.
Imagine we are leaving the realm of localized specific risks, like a damaged shipment or a forged note, and entering the vast interconnected ecosystem of modern commerce, corporate lending, and complex employment structures. In this arena, a simple two-party promise is often entirely insufficient.
It just doesn't work.
A bank, for instance, cannot simply trust a new business owner's promise to repay a massive loan. The risk of default is too high, and a two-party system offers no external security. To facilitate this flow of capital and commerce, the law engineered a more complex structure, a tripartite safety net. Enter the contract of guarantee.
This transition requires us to move from Section 124 to Section 126 of the Indian Contract Act. Section 126 defines a contract of guarantee with precise architecture. It is a contract to perform the promise or discharge the liability of a third person in case of his default.
Let's build a mental model for this. Earlier, we used the analogy of a firewall for indemnity. For guarantee, let's visualize a high-wire circus act.
Okay, set the stage.
The principal debtor, say, a young entrepreneur taking out a massive business loan, is the tightrope walker. They are attempting to cross a dangerous chasm of financial obligation. The creditor, the bank, is the circus owner. They want the walker to cross successfully because that generates profit, but they are terrified of the risk. They know gravity exists. They know businesses fail. So the circus owner refuses to let the act proceed without a safety net.
And the safety net is the third party.
Exactly. The surety is that safety net. Now here is the critical distinction from an indemnity firewall. The safety net does not actively protect the walker from falling. It does not engage during the normal course of the performance. The safety net simply hangs there, suspended, bearing no weight and doing absolutely nothing, until the exact moment the walker loses their balance and plummets. The net only activates upon default.
That analogy perfectly captures the conditional secondary nature of the obligation. To formally map this tripartite agreement to our legal terminology, we must identify the three distinct actors.
Right. Who are they?
First, we have the creditor. This is the person to whom the guarantee is given, the circus owner who requires the assurance before deploying their capital. Second, we have the principal debtor. This is the person in respect of whose default the guarantee is given, the tightrope walker bearing the primary burden of performance. And third, we have the surety. This is the person who gives the guarantee, the safety net itself, promising to catch the financial fallout.
Three actors intricately bound together. Now, the sources indicate that the primary objective of this contract is to ensure the fulfillment of an obligation, to inject trust into the system. What are the strict legal prerequisites, the essential characteristics required to weave this tripartite net?
The law demands several structural pillars be perfectly aligned. The first and most absolute requirement is the principal debtor's existence. This means there must be a valid, legally enforceable primary obligation existing between the creditor and the principal debtor.
Makes sense.
The logic is simple. A secondary safety net cannot exist if there is no primary tightrope act. You cannot guarantee a debt that is legally void from its inception. If the underlying loan contract is invalid, the guarantee evaporates instantly. Secondly, as with all valid legal instruments, there must be free consent among the parties. A surety cannot be coerced, forced, or fraudulently induced into assuming this massive liability.
I need to interrupt here because we are brushing up against a foundational rule of contract law that seems to entirely contradict the mechanics of a guarantee.
Oh, how so?
In standard contract theory, for an agreement to be binding, there must be consideration, a mutual exchange of value. I give you capital, you give me equity. If I'm the surety, if I'm volunteering to be the safety net, I'm assuming a terrifying amount of contingent liability to pay off someone else's debt. What is my compensation? Where is the consideration flowing directly into my hands to make my promise legally binding?
That is the exact paradox that Section 127 of the Indian Contract Act resolves, and it does so with a fascinating deviation from standard contract mechanics.
Okay, tell me more.
The legislature recognized that if the law strictly required the surety to receive a direct personal financial payoff, like a fee or a commission, the entire informal economy of guaranteeing loans for friends, family, or subsidiaries would instantly collapse.
Right, because people usually do it for free to be helpful.
Exactly. Therefore, Section 127 introduces a vital legal fiction. The consideration flows strictly to the principal debtor, yet it binds the surety.
So the law accepts that I am taking on the risk entirely altruistically. and it considers the benefit given to my friend as the legal glue that binds my promise.
Precisely. The statute explicitly declares that anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. The mere fact that the creditor agrees to extend a loan to the debtor or agrees to supply goods on credit to the debtor is considered legally adequate consideration to bind you, the surety. You do not need to receive a separate direct benefit. The act of the creditor extending their trust and capital to the debtor, based entirely on the strength of your word, is a consideration.
That is a profound mechanism of trust facilitation. Just give my sister the mortgage and I will back it. The bank giving her the keys to the house is the value that locks me into my liability.
Exactly.
Now, what about the capacity to play these roles? We know the general rule, right? Minors cannot enter into binding contracts. Does that apply across the board here?
Here, the sources reveal a highly dangerous nuance. While the surety must absolutely be fully competent to contract, meaning they are of sound mind in the age of majority because they are assuming massive contingent risk, the principal debtor actually can be a minor or a person otherwise incompetent to contract.
Wait, the tightrope walker could be someone who legally isn't allowed to sign a contract. How does that not void the entire structure? We just established that the principal debt must be valid.
It creates a fascinating legal transmutation.
Transmutation.
Yes. If the principal debtor is fundamentally incompetent to contract, say, a 17-year-old student, the primary loan agreement between the creditor and the minor is technically void. Therefore, the law cannot treat the surety as a secondary safety net because there is no legally binding primary act to fall from.
So the guarantee is void.
No, this is where the transmutation happens. In this specific scenario, the law actively shifts the burden. The surety is no longer regarded as a secondary guarantor. The law instantly transmutes the surety into the principal debtor. The surety becomes primarily and personally liable to pay the debt from day one. The creditor simply ignores the minor's legal existence in the transaction and looks directly to the adult who signed the paper.
Wow, that is a massive concealed trapdoor for anyone who co-signs a financial instrument for a minor, like a student loan or a car lease. You might think you're just offering a supportive background signature, but legally, the court views you as the primary borrower.
It happens more often than you'd think.
Now, let's discuss the integrity of the information. What happens if the circus owner lies to the safety net manufacturer about the weight of the tightrope walker? What if there is deception involved in securing the guarantee?
The law demands absolute, uncompromising good faith in the formation of a guarantee. If the creditor obtains the guarantee by means of misrepresentation regarding a material part of the transaction, or if the creditor deliberately keeps silence and conceals material circumstances, the guarantee is entirely invalid.
Give me an example.
For example, if a bank asks you to guarantee a business line of credit for an employee, but the bank secretly knows that an employee has been embezzling funds from the account and they hide that fact from you, the courts will annihilate that guarantee. The surety is stepping into a precarious position of extreme vulnerability. They must be fully apprised of the true nature of the risk they are assuming.
We have dissected the basic anatomy of the tripartite net. But guarantees are not monolithic. They are highly adaptable instruments tailored to different commercial realities. Let's move to Section 4 of our deep dive, kinds of guarantee and the scope of liability.
There are quite a few variations.
The sources outline a precise taxonomy. Instead of just listing them, let's construct complex, real-world scenarios to illustrate the terrifying differences in exposure between these types. Let's begin with the most common distinction. Specific versus continuing guarantees.
Okay, a specific guarantee is precisely targeted. It applies exclusively to a single, isolated debt or a singular defined transaction.
Yeah.
Once that specific obligation is discharged, the guarantee completely extinguishes.
Okay, so like a one-off thing.
Yes. Imagine you have a colleague who needs to purchase a highly specialized, expensive piece of manufacturing equipment, a CNC machine, for a new venture. The bank refuses to lend the 500,000 rupees without backing. You agree to sign a specific guarantee strictly for the loan on that single CNC machine. The colleague makes the final payment on that specific loan 3 years later. The moment the balance hits zero, your liability vanishes. If your colleague goes back to the bank the next day and borrows 1 million rupees for a warehouse, your original guarantee does not cover it. Your exposure was surgically confined.
A one-and-done legal mechanism. I like the safety of that. Now, contrast that with a continuing guarantee. How does the exposure profile change?
The exposure profile expands exponentially. A continuing guarantee extends not to a single event, but to a continuous, fluctuating series of transactions over an indefinite period until it is formally revoked or a predefined limit is reached.
That sounds dangerous. Give me a scenario.
Consider a scenario where you guarantee a running line of credit for a friend's restaurant to purchase daily inventory from a massive agricultural supplier. Your friend buys vegetables on Monday, pays the invoice on Thursday, buys meat on Friday, leaves a balance over the weekend, pays it down on Tuesday, and buys more on Wednesday. The debt balance is constantly rising and falling.
And you are liable for all of it.
A continuing guarantee covers this entire rolling process. You are continually on the hook for whatever the outstanding fluctuating balance happens to be on any given day, week after week, month after month. The liability constantly replenishes itself. It only stops if you formally notify the supplier that you are revoking the guarantee for any future transactions, or if the contract reaches a predefined expiration date.
So a continuing guarantee is vastly riskier because you are essentially underwriting an ongoing behavior pattern, not a single decision. You are tethered to the operational chaos of their business.
Exactly. It requires a lot more trust.
Okay, let's explore the trigger mechanisms. Absolute versus conditional guarantees.
An absolute guarantee represents an unconditional, immediate promise to pay the instant the principal debtor defaults. There are no procedural hurdles. The moment your friend's restaurant misses the Friday payment to the agricultural supplier, the supplier does not have to waste time calling your friend. They can immediately pivot, contact you, and demand the full payment. Your promise to pay was absolute upon default.
And a conditional guarantee.
A conditional guarantee, however, is far more defensive for the surety. It relies on a specific contingency or a series of procedural steps occurring before your liability activates. For instance, you might negotiate a clause stating that you will only pay if the creditor first exhausts all available legal remedies against the principal debtor.
That is a massive procedural buffer.
It is. In that scenario, if the restaurant defaults, the supplier cannot simply call you for a quick payout. The supplier must first file a lawsuit against the restaurant owner, obtain a judgment, attempt to seize the restaurant's assets, liquidate the inventory, and legally drain every ounce of capital from the primary debtor. Only after that entire exhaustive, months-long legal process is completed, if there is still a remaining deficit, can the supplier finally trigger your guarantee to cover the shortfall.
If you are ever forced to sign a guarantee, insisting on it being conditional upon the exhaustion of remedies could save you from immediate financial ambush.
Oh, absolutely. Always try to get that in.
Next categorization, general versus special guarantees. This seems to dictate who is allowed to hold the net.
Precisely. A general guarantee is a broad, open offer directed to the public at large. It is rarely used in high finance, but occurs in specific contexts. For example, a wealthy parent might issue a general guarantee, publicly declaring they will cover the debts of their newly adult child up to a limit of 100,000 rupees, regardless of who extends the credit. It is an open invitation. If a landlord, a car dealership, or a credit card company accepts that offer and extends credit to the child, the parent is bound to any of them.
Interesting. And special.
A special guarantee is laser-focused. It is restricted to a particular person, a specific bank, or a designated institution. You write a guarantee addressed explicitly to the State Bank of India, stating, "I guarantee the business loan you issue to this specific startup." If the startup takes that guarantee document and tries to use it to secure a loan from a different bank, it is useless. Only the State Bank of India possesses the legal authority to enforce your promise.
General is a shotgun blast of trust, and special is a sniper rifle. Now, the final two sets of classifications, let's do limited versus unlimited.
These are exactly what their names imply, but the consequences are profound. A limited guarantee has a hard contractual ceiling. You explicitly state, "I guarantee the obligations of this enterprise up to a maximum strict limit of 1 million rupees. If the enterprise aggressively expands, takes on 5 million rupees in debt, and catastrophically defaults, your exposure is halted exactly at the 1 million rupee mark."
Right. And unlimited.
An unlimited guarantee lacks that ceiling. It is terrifyingly expansive. You are guaranteeing the entire scope of the debt, whatever it may grow to become. If the business takes on millions in principal, racks up exorbitant compound interest, and incurs devastating legal penalties, you are liable for the entire mountain of debt.
I cannot emphasize this enough. Signing an unlimited guarantee is akin to writing a blank check drawn on your future. Always demand a cap.
Sound advice. Always.
Finally, prospective versus retrospective guarantees.
This classification deals strictly with the dimension of time. A prospective guarantee looks forward. It covers future transactions debts that have not yet been incurred at the moment the guarantee is signed. This is the standard mechanism for new loans or new lines of credit. A retrospective guarantee, however, looks backward. It is designed to cover past, already existing debts.
Why would anyone volunteer to guarantee a debt that is already in existence? That seems wild.
Usually as a desperate stabilization tactic. Imagine a manufacturing company is deeply in arrears on an existing loan, and the bank is threatening to initiate foreclosure proceedings tomorrow. To save the company, a wealthy investor or a parent company steps in today and offers a retrospective guarantee on that existing debt. They do this to alter the bank's risk calculus, convincing the bank to halt the foreclosure and grant the struggling company more time to restructure and survive.
That menu of guarantees demonstrates how highly customizable these instruments are. But despite all these variations, there is a core, terrifying principle regarding the depth of your liability that you must fully grasp. This brings us to what I consider the most intimidating statutory phrase in our entire deep dive.
I think I know the one.
The expert introduces Section 128 of the Indian Contract Act. What is the fundamental rule governing the scope of a surety's exposure?
Section 128 states with chilling clarity: the liability of the surety is coextensive with that of the principal debtor, unless it is otherwise provided by the contract.
Coextensive, that is a heavy architectural word. Let's translate that out of legalese. What does coextensive actually mean for you, the listener, if you casually sit down at a desk, sign a standard guarantee form for a friend, and fail to negotiate any special limits or caps into the text?
It means you are stepping into a financial mirror. Your liability becomes an exact pixel-for-pixel reflection of the principal debtor's liability. You are inextricably linked to the total mass of their obligation.
Okay, walk me through the math on that.
Sure. If the principal debtor owes the initial 100,000 rupee loan amount, your reflection in the mirror owes 100,000 rupees. If the debtor misses payments and accumulates 20,000 rupees in crippling compound interest, your reflection instantly takes on that 20,000 rupees of interest. If the bank is forced to hire aggressive recovery agents and spend 50,000 rupees in legal fees and penalty charges to pursue the debtor, and those fees are legally added to the debtor's overall balance, your reflection absorbs those legal fees and penalty charges as well. Your liability is exactly as wide, as deep, and as vast as theirs.
This is a crucial point of failure for many people's understanding, because the surety's liability is defined as secondary, meaning the bank has to wait for the debtor to fail before they look at you. People falsely assume secondary means partial or lesser, but that is entirely wrong.
It is a catastrophic misunderstanding. Secondary liability does not dilute the sheer volume of the debt. It simply dictates the sequence of collection. You are second in line, but you take the full, undiminished force of the blow. The moment the default occurs, the sequence shifts, and your liability becomes absolute and identical to the debtor's. You cannot stand before a judge and plead, "Oh, I only ever intended to back the principal loan amount. I never agreed to pay their late fees or the bank's lawyer costs." If you did not explicitly write a limitation into the contract, the law defaults to Section 128. The law assumes your liability is entirely coextensive.
The financial mirror reflects everything. It is a sobering reality that underscores the extreme danger of casually extending your creditworthiness to another person. We have covered an immense expanse of legal territory today. We have thoroughly dismantled the direct protective firewall of indemnity, and we have navigated the intricate, tripartite safety net of guarantee. To truly synthesize this knowledge for you, let's move to Section 5, the ultimate face-off: indemnity versus guarantee.
An excellent pedagogical exercise. Let's begin with the most fundamental architectural difference.
We're going to execute a rapid-fire comparative analysis. We will place these two structures side by side to ensure the conceptual boundaries between them are crystal clear. Let's look at the number of parties.
In a contract of indemnity, it is a strictly contained ecosystem of two parties: the indemnifier, who makes the promise of protection, and the indemnified, who holds the shield and receives the protection. In a contract of guarantee, the ecosystem expands to three essential parties: the creditor, who extends the capital or trust, the principal debtor, who receives the capital and bears the primary burden, and the surety, who acts as the secondary safety net.
Moving to the underlying legal framework, the number of contracts involved.
In an indemnity, the structure is clean and singular. There is exactly one contract existing solely between the indemnifier and the indemnified. A guarantee, however, is a complex constellation. Because there are three parties, there are actually three interrelated contracts functioning simultaneously to hold the structure together.
Let's trace those three contracts, because that is a vital concept. The first is obvious. The primary contract between the creditor and the principal debtor, the actual loan agreement or lease. The second is the contract between the creditor and the surety, the document that forms the safety net itself. Where is the hidden third contract?
The third is an implied contract existing between the principal debtor and the surety. Even if the friend you are backing never signs a document directly with you, the law implies a contract of indemnity between you two. The law states that if the surety is forced to pay the creditor due to the debtor's default, the debtor has an implied binding legal obligation to reimburse the surety for that exact amount.
The law automatically builds a backdoor mechanism for the surety to try and recover their losses from the person who caused them. Brilliant. Next comparison metric. The nature of liability.
In indemnity, the liability assumed by the indemnifier is primary and absolute. They take on direct, complete responsibility for the specific loss the moment it becomes certain. In a guarantee, the liability of the surety is inherently secondary. The primary responsibility to perform always rests on the shoulders of the principal debtor. The surety remains in the shadows. Their liability is contingent, stepping into the light only if the primary actor fails.
Which leads directly into the actual trigger for liability. What sets the machinery in motion?
For an indemnity contract, the trigger is the occurrence of the anticipated loss, or, under the modern equitable rules we discussed, the liability of the indemnity holder becoming absolute and certain, like a court judgment being issued. For a guarantee, there is only one singular trigger: the default of the third party. If the principal debtor performs flawlessly, the guarantee is never triggered.
Let's elevate this to a conceptual level. What is the philosophical purpose driving these two different legal instruments?
The driving purpose of an indemnity is pure protection and risk containment. It is designed to provide financial security against a potential future uncertain loss. It is an inherently defensive maneuver. The purpose of a guarantee is facilitation and the engineering of trust. It is designed to ensure the fulfillment of a contract or guarantee the repayment of a debt. It exists to grease the wheels of commerce, allowing loans to be issued and business to be conducted in situations where the creditor's natural risk tolerance would otherwise halt the transaction. It is an enabling maneuver.
And finally, let's examine the aftermath rights. The dust has settled, the protector has paid out the money. What power do they have now?
This is a highly critical distinction regarding recovery. In an indemnity, once the indemnifier fully compensates the indemnity holder for the loss, the indemnifier's rights are generally limited to whatever was specifically agreed upon in their contract. However, under the principles of equity, they can be subrogated to the rights of the indemnified. This means they can essentially take over the legal position of the person they protected and attempt to sue whoever actually caused the original damage, trying to claw back their money.
Okay, and in a guarantee?
But in a guarantee, the mechanism is far more automatic and powerful. The very millisecond the surety pays off the creditor to satisfy the debtor's default, the surety is immediately and automatically subrogated. They step directly into the exact legal shoes of the creditor.
Meaning the surety instantly inherits every single right, weapon, and security interest the massive bank possessed against the debtor.
Absolutely. The surety can now sue the principal debtor with the exact same legal force the bank had, demanding repayment for everything they were forced to pay out. Furthermore, if the risk was shared, if there were other co-sureties who also signed the guarantee, the surety who paid the full amount can immediately demand proportional contribution from those co-sureties. The law equips the surety with a highly weaponized set of rights to aggressively recover their capital.
That comparative analysis perfectly sharpens the boundaries between these two massive concepts. We have undertaken a truly exhaustive journey today through the intricacies of Paper 1, Law of Contract 2. To synthesize this deep dive for you, we've explored the invisible, complex architecture that allows human beings and corporations to engineer trust and manage existential financial risk.
We covered a lot of ground.
We really did. We dismantled the direct two-party firewall of an indemnity contract, analyzing how it strictly insulates you from defined losses, how the law violently refuses to shield malice or illegal behavior, and how modern courts of equity evolve to ensure you don't have to face utter financial ruin before that firewall activates to protect you. We also plunged into the terrifying invisible world of implied indemnity, where your simple requests can forge unwritten, binding contracts of liability.
Yeah, that's the one that really gets people.
We then transitioned to the interconnected world of the guarantee, dissecting the tripartite safety net. We explored how it facilitates global commerce by providing a secondary backstop of trust, the vital legal fiction of consideration that binds it, the highly customizable menu of specific and continuing limits, and the absolute coextensive danger of stepping into a financial mirror with a defaulting debtor.
It's all about risk management.
Whether you are navigating commercial insurance policies, analyzing complex corporate structures, or simply standing in a bank deciding whether to co-sign a loan for a family member, these contracts are the invisible bedrock upon which our entire economic reality is built.
They're the quiet, relentless gears that allow individuals, entrepreneurs, and megacorporations to accurately calculate and survive the inherent risks of existence.
Now, before we conclude this session, our expert has a final provocative thought to leave you with, something to mull over that builds on the profound realities we discussed.
It is. I want you to think about how frequently and how casually you ask your friends, colleagues, or neighbors for seemingly innocuous favors. Hey, can I borrow your truck to move some equipment? Can you drop this sealed hard drive off at the courier for my business? Can you temporarily hold this asset in your name while I finalize the paperwork?
We do it all the time.
If your simple, casual request sets off an unforeseen chain of events that results in your friend getting sued or suffering a catastrophic financial loss, you might be legally bound to completely indemnify them. The courts could force you to pay every cent of their legal defense and damages, even if you never signed a single piece of paper, and even if you had no malicious intent.
Just because you asked.
Just because you asked. It raises a deeply fascinating, almost unsettling philosophical question regarding our interpersonal relationships. At what exact invisible threshold does a simple, friendly request over coffee transform into a binding, unwritten, high-stakes contract of risk transfer in the cold, calculating eyes of the law? Next time you casually ask someone to stick their neck out for you, remember the profound precedent of implied indemnity. The law might fully expect you to be their absolute shield when the fire starts.
That is a thought that will fundamentally alter how I view every favor I ask or grant. It proves that the law isn't just in the textbooks. It is woven into our every conversation. Thank you for joining us for this deep dive. Keep questioning the invisible architecture that governs our world, and we will see you in the next session.